Defendants in this case argue, with Roe v. Wade being overturned at the federal level, the state's 1849 abortion ban law should stand.
Section 940.04 applies to prohibit consensual abortions from conception until birth, subject to an exception when it is necessary to save the life of the mother.
At present, that law is not being enforced. In a ruling last year, a Dane County Circuit Court judge ruled the state's 1849 ban only outlaws feticide, which they define as the killing of a fetus without the mother's consent. In the 1950s, lawmakers changed the law's language to allow a doctor, in consultation with two other physicians, to perform an abortion to save the mother's life. During the hearing, Justice Jill Karofsky pointed out the 1849 ban doesn't include exceptions for instances like rape or incest.
You know what? I'm talking about real life. I'm talking about the implication of what these decisions have on women and children and pregnant people in this state. That's what I'm talking about.
And Justice Karofsky, I think the legislature is the proper branch to take into effect those policy considerations. The reality is there are many abortions that are performed where the woman's life is not in danger and where the woman's health is not in danger. There's a clear-cut core of conduct to which the statute can be applied without raising any of these vagueness considerations.
Democratic Attorney General Josh Kaul's team relies on a 1985 state law which allows abortions before a fetus can survive outside the womb, which they argue replaces the ban.
The state of Wisconsin cannot have two laws on the same subject with the same scope that provide directly conflicting answers as to when conduct is and is not a felony.
However, the 1849 statute has not been repealed by the legislature, and defendants argue the ban can coexist with the 1985 law.
Indeed, they have expressly declined to do so at multiple opportunities, and until they do, it can be enforced.
The judiciary doesn't get to edit laws. The judiciary doesn't get to rewrite them. We didn't delete it. We prevented its enforcement. Now it's still there. How can we just say, oh, we can't enforce it anymore, simply because the legislature was doing other things when it was unenforceable?
It's expected to take weeks until we learn of a formal ruling by the state's highest court. Andrew Mertens, Fox 11 News.